3. It must have been peaceable and acquiesced in, no subject to contention and dispute. For as customs owe their original to common consent, their being immemorially disputed, either at law or otherwise, is a proof that such consent was wanting. 4. Customs must be reasonable, or rather, taken negatively, they must not be unreasonable, which is not always, as Sir Edward Coke says, to be understood of every unlearned man's reason, but of artificial and legal reason, warranted by authority of law, upon which account a custom may be good, though the particular reason of it cannot be assigned. For it sufficeth, if no good legal reason can be assigned against it. Thus, a custom in a parish, that no man shall put his beast into the common till the 3rd of October, would be good, and yet it would be hard to show the reason why that day in particular is fixed upon, rather than the day before or after. But a custom that no cattle shall be put in till the lord of the manor has first put in his, is unreasonable, and therefore bad, for peradventure the lord will never put in his, and then the tenants will lose all their profits. 5. Customs ought to be certain. A custom that lands shall descend to the most worthy of the owner's blood is void, for how shall this worth be determined? But a custom to descend to the next male of the blood, exclusive of females, is certain, and therefore good. A custom to pay 2d. an acre in lieu of tithes is good, but to pay sometimes 2d. and sometimes 3d, as the occupier of the land pleases, is bad for its uncertainty. Yet a custom to pay a year's improved value for a fine on a copyhold estate is good, though the value is a thing uncertain. For the value may at any time be ascertained, and the maxim of law is, id certum est, quod certum redi potest. 6. Customs, though established by consent, must be, when established, compulsory, and not left to the option of every man, whether he will use them or not. Therefore, a custom that all the inhabitants shall be rated toward the maintenance of a bridge will be good. But a custom that every man is to contribute thereto at his own pleasure is idle and absurd, and indeed no custom at all. 7. Lastly, customs must be consistent with each other. One custom cannot be set up in opposition to another, for if both are really customs, they both are of equal antiquity, and both established by mutual consent, which to say of contradictory customs is absurd. Therefore, if one man prescribes that by custom he has a right to have windows looking into another's garden, the other cannot claim a right by custom to stop up or obstruct those windows. For these two contradictory customs cannot both be good, nor both stand together. He ought rather to deny the existence of the former custom. Next, as to the allowance of special customs, customs, in derogation of the common law, must be construed strictly. Thus, by the custom of gavelkind, an infant of 15 years may be one species of conveyance, called a deed of feoffment, convey away his land in fee simple, or for ever. Yet this custom does not empower him to use any other conveyance, or even to lease them for 7 years, for the custom must be strictly pursued, and, moreover, all special customs must submit to the king's prerogative. Therefore, if the king purchases land of the nature of gavelkind, where all the sons inherit equally, yet, upon the king's demise, his eldest son shall succeed to those lands alone, and thus much for the second part of the legis non scripte, or those particular customs which affect particular persons or districts only. 3. The third branch of them are those particular laws which by custom are adopted and used only in certain peculiar courts and jurisdictions, and by these I understand the civil and canon laws. It may seem a little improper at first view to rank these laws under the head of leges non scriptae, or unwritten laws, seeing they are set forth by authority in their pandects, their codes, and their institutions, their councils, decrees, and decretals, and enforced by an immense number of expositions, decisions, and treatises of the learned in both branches of the law. But I do this after the example of Sir Matthew Hale, because it is most plain that it is not on account of their being written laws that either the canon law or the civil law have any obligation within this kingdom, neither do their force and efficacy depend upon their own intrinsic authority, which is the case of our written laws or acts of Parliament. They bind not the subjects of England, because their materials were collected from popes or emperors, were digested by Justinian, or declared to be authentic by Gregory. These considerations gave them no authority here, for the legislature of England doth not, nor ever did, recognize any foreign power as superior or equal to it in this kingdom, or as having the right to give law to any, the meanest of its subject. But all the strength that either the papal or imperial laws have obtained in this realm, or indeed in any other kingdom in Europe, is only because they have been admitted and received by immemorial usage and custom in some particular cases, and some particular courts, and then they form a branch of the leges non scriptae, or customary law, or else because they are in some other cases introduced by consent of Parliament, and then they owe their validity to the leges scriptae, or statute law. This is expressly declared in those remarkable words of the Statute 25 Henry VIII, Chapter 21, addressed to the King's Royal Majesty. Quote, "This your Grace's realm, recognizing no superior under God, but only your Grace, has been and is free from subjection to any man's laws, but only to such as have been devised, made, and ordained within this realm for the wealth of the same, or to such other, as by sufferance of your Grace and your progenitors, the people of this your realm have taken at their free liberty, by their own consent, to be used among them, and have bound themselves by long use and custom to the observance of the same, not as to the observance of the laws of any foreign prince, potentate, or prelate, but as to the customed and ancient laws of this realm, originally established as laws of the same by the said sufferance, consents, and customs, and none otherwise." End quote. By the civil law, absolutely taken, is generally understood the civil or municipal law of the Roman Empire, as comprised in the institutes, the codes, and the digest of the Emperor Justinian, and the novel constitutions of himself and some of his successors, of which, as there will frequently be occasions to cite them, by way of illustrating our own laws, it may not be amiss to give a short and general account. The Roman law, founded first upon the regal constitutions of their ancient kings, next upon the 12 tables of the Decemviri, then upon the laws or statutes enacted by the Senate or people, the edicts of the praetor, and the responsa prudentum, or opinions of learned lawyers, and lastly upon the imperial decrees, or constitutions of successive emperors, has grown to so great a bulk, or, as Livy expresses it,